I want you to imagine, just for a second, signing a contract.
Right, like a legally binding agreement.
Exactly. It could be for anything, really. Let's say you are starting a business with a partner, and you sign this massive long-term lease on a commercial property.
So you are taking on some serious financial and legal obligations.
Huge obligations.
Yeah.
You put your name on the dotted line. You make these heavy commitments. But now, I want you to imagine that hidden deep in the fine print of the law that governs that contract, there is a very specific rule.
Uh-oh. The fine print is usually where the trouble starts.
Oh, it is. This rule states that the other party can dissolve the entire agreement at any time.
Just like whenever they feel like it.
Whenever they want. They do not need your consent. They do not need to prove that you did anything wrong. They don't have to show any objective evidence of a breach of contract whatsoever.
That is wild.
Right. All they have to do is simply state to a judge that they believe the contract is broken. And then picture yourself standing in front of that judge, armed with your documents, ready to argue your side, only to be told that your opposing belief, your assertion that the contract is actually perfectly fine, is legally meaningless.
Yeah, that your viewpoint basically holds zero weight in the eyes of the state.
Exactly. Your opposing belief is completely irrelevant.
I mean, that runs completely contrary to everything we intuitively understand about contracts, in a civilized society.
Right. It feels fundamentally unfair.
It does. We expect that if a contract of immense consequence is going to be broken, there has to be a real demonstrable reason, like a failure to pay.
Or a failure to deliver goods.
Right. A documented breach of some specific duty.
But, and this is the kicker, in the context of the most common civil contract that citizens enter into, which is the marriage contract, that is exactly how the law operates in almost every jurisdiction today.
It really is. Your opposing belief is legally meaningless.
That is the reality of the modern marriage contract. And today, we are taking a deep dive into what I can only describe as a legal time bomb.
A massive one, yeah.
We are examining a case where a single pro se litigant, meaning an individual representing himself without a lawyer, has dug up this, 200-year-old Supreme Court loophole.
Which is fascinating all on its own.
Right. And he paired it with a brand new First Amendment ruling to argue that 50 years of no-fault divorce is entirely unconstitutional.
It is a really ambitious legal strategy.
It is. Now, before we jump in, we need to be very clear with you, the listener. We're dealing with some intensely charged issues today.
Oh, definitely. From the legal definition of marriage to state bans on conversion therapy.
Exactly. So we are treating these source texts strictly as legal architecture. We aren't here to debate the morality of these policies.
Right, we are not taking political sides here.
Not at all. Our job is just to dissect the constitutional mechanics of the arguments in these filings. We want to explore how a seemingly unrelated Supreme Court case might just blow the foundation of family law wide open.
Okay, let's unpack this, because it really is a remarkable convergence of legal doctrines.
It is.
On one hand, we are looking at the foundational principles of contract law and the state's historical power over domestic relations.
Right.
But on the other hand, we have the absolute cutting-edge boundaries of First Amendment jurisprudence, like free speech, state power, and viewpoint discrimination.
So let's start with the human element, because all of this architecture, it begins with a specific family in Oklahoma.
Right. The case is a pending petition for writ of certiorari called Aikins v. Aikins.
So James and Rachel Aikins,
Mm-hmm.
they were married in December of 2006, and they have two minor sons who are currently 14 and 12 years old.
Okay.
In August of 2023, Rachel filed a petition for dissolution of marriage. And the statutory ground she cited was a state of complete and irreconcilable incompatibility.
And that is under Oklahoma statute, Title 43, Section 101, subsection 7.
Right, exactly. Now, James immediately opposed the divorce. He filed a response asserting that the marriage was not incompatible.
And the human stakes here, they are really stark. Because according to the case filings, James hasn't seen or talked to his sons since December 20th, 2022.
That is over 3 years of complete separation.
Yeah, and that's despite the fact that prior to that date, he was their primary caregiver.
And wait, I want to clarify something here because this is a massive part of the specific context we are looking at.
Yeah.
During these proceedings, there were no witnesses at all.
Right, zero. No witnesses or evidence was presented in court by the petitioner.
Or her attorney.
Not her attorney, not even the guardian ad litem. There was no evidence of any kind of abuse toward the wife or the children.
Wow. Okay, but what about the medical issues mentioned in the filings?
Well, all the medical and mental health issues, the behavioral issues, the husband argued those were completely pre-existing.
So they were not originally caused by the husband or the father.
Exactly. He argued that these were just allegations made by the wife specifically to affect the custody of the children.
Like to frame herself as the innocent spouse.
Precisely. He is essentially saying, you are taking my children, my property, and my civil status without proving I did anything wrong.
Which brings us to the fascinating legal pivot James makes here.
Right, because in a typical contested divorce, the battle lines are drawn over the results of the dissolution.
Yeah, like who gets the house?
Right, you fight over alimony, the visitation schedule, the assets.
But James didn't do that.
No, he took a fundamentally different approach. He filed a motion to dismiss. He challenged the actual subject matter jurisdiction of the court.
Wait, hold on. Subject matter jurisdiction. That sounds like a really dry procedural term, but it's actually like a nuclear option in litigation, right?
Oh, absolutely. It is the nuclear option.
Because if you argue subject matter jurisdiction, you aren't just arguing about the rules of the game. You are arguing the referee has no legal authority to even be on the field.
That is a great way to put it. You are saying the court lacks the fundamental constitutional power to even hear the case in the first place.
So James argued that the Oklahoma no-fault divorce statute is unconstitutional on its face.
Yes. And to really grasp why this is such a massive challenge, we have to look back at the historical context of no-fault divorce.
That's how we even got here.
Yeah. So beginning in the late 1960s and sweeping through the 70s, states universally adopted some form of no-fault divorce.
Because prior to that, you had to prove a traditional fault. Right?
Exactly. Adultery, extreme cruelty, abandonment, stuff like that.
Which led to a huge sociological problem.
It did, because if two people simply hated each other and wanted out, but neither had technically committed a legally recognized fault,
they were just trapped.
Completely trapped. And that led to this era of manufactured perjury.
Oh, right. Like the staged photos in hotel rooms.
Yes. You had couples in states like New York legally staging fake adulterous affairs. They would literally hire private investigators to take photos of a spouse with an actor just to generate the evidence required by the court.
That is so wild to think about.
Well, the legal system realized that forcing people to fabricate evidence just to end a broken marriage was degrading the integrity of the courts.
So the no-fault revolution happened.
It did. But James's argument forces us to look at how that actually happened from a structural legal perspective.
Okay, lay it on me.
Under the advent of no-fault laws, the state didn't just tweak the rules. The actual cause of action fundamentally changed.
What exactly constitutes a cause of action, legally speaking?
Well, traditionally, a cause of action requires 4 essential interlocking elements.
Okay, what is the first one?
First, a primary right held by the plaintiff.
Like the right to a fulfilled contract?
Yes. Second, a corresponding duty owed by the defendant.
Like the duty to pay rent or in a marriage, fidelity?
Right. Third, a breach of that duty by the defendant.
And the fourth?
A remedy flowing from that breach.
Okay, so right, duty, breach, and remedy.
Exactly. But James argues, and he cites cases like Page v. Winter for this, that the no-fault divorce framework entirely bypassed the element of a breach.
Wait, they just removed the breach element entirely?
Yes. The modern statute doesn't establish any identifiable duty imposed on the respondent, nor is there any requirement for the petitioner to demonstrate a breach of duty.
So what does it hinge on?
It hinges entirely on one party's subjective belief, rather than objective misconduct.
Which brings us right back to the incompatibility statute.
Right. The mere allegation of incompatibility is completely sufficient to effectuate the dissolution. There are no defenses permitted.
So the respondent's opposing belief that the marriage is not incompatible, it really is legally irrelevant to the outcome.
It holds 0 weight.
So James is basically saying, wait a minute, you are allowing the state to strip me of my civil status, alter my parental rights, and divide my property without me having breached any legal duty.
Just because the other party believes you are incompatible.
Right. And because no objective evidence of abuse or misconduct was ever presented, this isn't a legal adjudication. It is just a state-sponsored rubber stamp.
And the state of Oklahoma, through the wife's response and the trial court's eventual rulings, They offer the classic impenetrable defense of the modern no-fault system.
Which is what?
They argue that the legislature possesses ultimate plenary power over the dissolution of marriage.
Plenary power. That essentially means absolute, unqualified power.
Yes, absolute power. The state is saying, we make the rules of reality when it comes to marriage.
That is quite the claim.
Well, they cite foundational state cases like Williams v. Williams. That case firmly states that the state has a sovereign constitutional right to declare and maintain a policy regarding marriage and divorce for persons within its borders.
So the state is basically an invisible third party to every marriage contract.
That is exactly how they view it. And the state's argument also relies heavily on a Nebraska case, Dicus v. Dicus.
What happened in Dicus?
In that case, the court explicitly stated that the state has plenary power to fix the conditions under which marital status may be created or terminated.
Okay, but what about the right to marry?
Crucially, the state argues that if you look at U.S. Supreme Court decisions regarding the right to marry, there is nothing suggesting an individual has a constitutional liberty interest in forcing someone to stay in a broken marriage.
Just because the defendant wasn't at fault.
Right. It is the ultimate trump card for the state. If the legislature decides that incompatibility is the new standard, then incompatibility is the standard. End of story.
But this is exactly where James Aikins pivots from family law to constitutional law.
Because if the state claims absolute unchecked power over the marriage contract, James looks back deep into the archives of the Supreme Court to prove that the Constitution places a hard, undeniable limit on that power.
He bypasses decades of family law precedent.
Completely bypasses it. He goes straight for the foundation of American contract law. He invokes a case from 1819.
Dartmouth College v. Woodward.
Yes.
I really want to spend some time here, because finding this argument, it is just a piece of sheer legal archaeology.
It really is brilliant.
We are talking about Chief Justice John Marshall, one of the most influential jurists in American history, writing this opinion.
Right. Dartmouth College is the bedrock case interpreting the contract clause of the U.S. Constitution.
That is Article 1, Section 10, right?
Yes. And it is very clear. It says, no state shall pass any law impairing the obligation of contracts.
So what were the facts of the Dartmouth case?
It involved the state of New Hampshire attempting to unilaterally change Dartmouth College's corporate charter. The state wanted to turn a private institution into a public one.
And Marshall said no.
Right. Chief Justice Marshall famously ruled that a corporate charter is a contract, and the state legislature cannot simply pass a law to impair or alter it without the consent of the parties.
But Marshall was incredibly forward-thinking. He knew that writing such a sweeping, broad rule about contracts might have massive unintended consequences.
Especially for other types of state-regulated agreements.
Exactly, particularly the most fundamental civil agreement of all, which is marriage.
Because if the state can't ever alter a contract without mutual consent, how could a state grant a divorce if, say, a husband abandoned his wife but refused to consent to the dissolution?
Right, so Marshall actually wrote a specific carve-out into the opinion,
which James Aikins refers to in his briefs as the Dartmouth exception.
Marshall explicitly wanted to clarify the boundaries of state power over domestic relations.
Right. He noted that marriage is indeed a civil contract, but it's not a mere business contract. The state has a profound legitimate interest in regulating it for the health and safety of society.
However, and this is the absolute crux of James's entire contract clause argument, Marshall placed a very specific hypothetical boundary on that state power.
He did.
I actually have the exact quote from Marshall in the 1819 Dartmouth decision right here.
Yeah.
And honestly, reading it in the context of modern divorce is chilling.
Go ahead and read it.
He wrote, "When any state legislature shall pass an act annulling all marriage contracts, or allowing either party to annul it without the consent of the other, it will be time enough to inquire whether such an act be constitutional."
That is the Dartmouth exception right there.
Marshall is basically signaling to future generations.
He is. He is saying, yes, the state can regulate marriage. It can grant divorces for cause, for a demonstrable breach of the contract, like abandonment or cruelty.
But if a state ever passes a law that allows one party to unilaterally dissolve the contract without the consent of the other party,
and without requiring proof of a breach,
then the Supreme Court will have to step in. They will have to determine if that fundamentally violates the contract clause of the Constitution.
And James Aikins points directly at the Oklahoma statute, the incompatibility statute, and he says, look at the mechanism. This is exactly what Chief Justice Marshall was warning about 2 centuries ago.
It is uncanny. His argument is meticulously constructed.
It is. He breaks down the Oklahoma statute to show how it fulfills every single condition of Marshall's warning.
Okay, let's walk through that.
Well, it allows unilateral dissolution without consent because the respondent's opposition is legally irrelevant.
Right, we established that.
And it allows dissolution without breach because there is no objective fault or misconduct required to be proven.
And there was no evidence of abuse in this case anyway.
Exactly. And finally, it allows dissolution without meaningful judicial review.
Let's expand on that meaningful judicial review part. James argues that the judges in these no-fault cases aren't actually acting as adjudicators.
No, he says they are acting as ministerial agents.
What does that mean in this context for the listener?
So when a judge adjudicates, they weigh evidence, they assess credibility, and they determine facts based on opposing arguments.
Like a real trial.
Right. A ministerial duty, on the other hand, is an administrative act. It's carried out by an official according to a mandate without the exercise of personal judgment.
Oh, I see.
James is arguing that because the statute makes the wife's subjective belief of incompatibility conclusive, the judge isn't weighing anything. The judge has no discretion.
The judge is merely performing a ministerial duty.
Yes, just rubber stamping the petitioner's belief and dissolving the contract. Therefore, the court isn't actually providing judicial review of the contract's dissolution at all.
So James presents this incredibly tight historical argument. But how does the Oklahoma Court of Civil Appeals handle it? I mean, how do they brush away a 200-year-old Supreme Court Chief Justice leaving a constitutional trapdoor open?
Well, the Court of Appeals rejected James's argument by relying on the established modern narrative.
Which is?
They cited a couple of major historical cases to support the idea that marriage is more than a mere contract, and therefore it can be freely modified by the state legislature without violating the contract clause.
What cases did they use?
Specifically, they cited a 1970 New York case called Gleason v. Gleason, and an 1888 Supreme Court case called Maynard v. Hill, which originated in the Oregon Territory.
But wait, if I'm just a pro se litigant and the appellate court hits me with an 1888 Supreme Court case and a 1970 state Supreme Court case, most people would just fold.
Oh, absolutely. It's intimidating.
But James didn't fold. He went into the archives and completely dismantled those citations.
He really did. His reply brief surgically dissects those two cases to demonstrate why they absolutely do not foreclose his constitutional challenge.
Okay, let's look at how he dismantled Gleason first.
So, the Oklahoma Court of Appeals cited Gleason to support the premise that the legislature has the general, unquestioned right to legislate the subject of divorces.
Okay, sounds standard.
But James points out the specific factual mechanism of Gleason. That case involved New York's 1966 divorce statute, and that specific statute permitted divorce after the parties lived apart under a written separation agreement or a judicial decree.
Wait, both of those conditions inherently require mutual consent.
Exactly.
So the court is citing a case about mutual consent to justify a statute about unilateral dissolution.
Yes. James argues that Gleason's reasoning that contract principles are satisfied when both parties agree to the separation has absolutely no application to Oklahoma's statute because Oklahoma requires no consent at all from the respondent.
He even notes the historical irony here.
He does. New York didn't even enact unilateral no-fault divorce until 2010. That is 40 years after the Gleason case was decided.
Wow. So using Gleason to defend unilateral divorce is chronologically and factually absurd.
It really is a stretch.
Okay, what about the Supreme Court case? Maynard v. Hill from 1888. The court used that to say marriage is more than a mere contract.
James is equally lethal with Maynard. He points out the jurisdictional and historical context.
Which was?
Maynard addressed a legislative divorce granted by the Oregon Territorial Legislature in 1852.
Why does it matter that it was a territory?
Because Oregon was a territory at the time, not a state. It operated without a state constitution, without a strict separation of powers, and crucially, without a system for judicial divorces.
So the legislature just passed a bill divorcing a specific couple.
Exactly. And Oklahoma's governmental structure today, with its strict separation of powers and judicial courts, is the exact opposite of that territorial framework.
Furthermore, James notes that Maynard came 69 years after Dartmouth.
Right.
When the Maynard court held that marriage is more than a mere contract, they meant it requires greater protection, not less.
Yes, Maynard explicitly stated that marriage could not, like mere contracts, be dissolved by the mutual consent of the contracting parties.
because that would violate the government's vital role in regulating the institution.
Exactly. James argues that the Oklahoma Court of Appeals basically twisted these historical cases to conclude the exact opposite of the framework the original justices were drawing.
The central thesis of James's petition regarding the contract clause is profound.
It is. He argues that no court in the United States has ever actually adjudicated the Dartmouth exception on its merits for a modern, unilateral, no-fault judicial divorce.
That is a huge claim.
He argues that whenever this challenge is raised, courts sidestep the confrontation by mischaracterizing the issue, just as he claims the Oklahoma Court of Appeals did by lazily citing mutual consent and territorial cases that don't even apply.
The implication here is staggering. He is suggesting that the legal scaffolding holding up 50 years of divorce law across the entire country has this massive constitutional blind spot the courts are actively refusing to look at.
That is exactly his point.
But as compelling as this historical contract clause argument is, if I'm the state of Oklahoma, I'm just going to argue that divorce isn't just about a contract.
Right. They will say it's an administrative procedural dissolution.
Yeah, how does James get around the fact that courts view divorce as a procedural dissolution of a status and not a debate over ideas?
Well, this bridges us to his second, completely independent ground for dismissal. And this is where the case crashes headlong into the modern culture wars.
Oh, boy.
Yeah, this is where we shift from the impairment of historical contracts to the modern regulation of speech and belief.
Okay, let's get into it.
James argues that by utilizing this specific mechanism for divorce, the Oklahoma statute engages in viewpoint discrimination, violating his First Amendment rights.
Okay, we really need to carefully break down the mechanics of this. How does a seemingly mundane family law statute regarding divorce discriminate based on viewpoint?
It all comes back to the lack of objective evidence.
The part we highlighted earlier.
Exactly. According to the briefs, the statute operates entirely on subjective belief. The petitioner, Rachel, stated she believed the marriage was incompatible.
And the respondent, James, stated he believed the marriage was not incompatible.
Right. Jones argues that the state statute is designed to give conclusive legal effect to the petitioner's belief, while simultaneously rendering the respondent's opposing belief legally meaningless.
Because there are no affirmative defenses permitted.
None. You cannot introduce objective evidence like bank statements, character witnesses, or psychological evaluations to prove the marriage is compatible.
So the government is essentially endorsing one viewpoint regarding the state of a relationship and systematically silencing the other.
That is his exact argument. He quotes the landmark First Amendment case, West Virginia Board of Education v. Barnett.
That is the famous 1943 case, right?
Yeah.
Where the Supreme Court ruled that students could not be forced to salute the flag.
Yes. The court stated that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion.
So James is saying that by forcing the court to dissolve the marriage based solely on the wife's unproven assertion of incompatibility, the state is prescribing an orthodoxy of opinion.
Right. The state is saying her opinion of the relationship is the only orthodox truth.
And this ties directly back to his argument about the lack of a breach or objective misconduct.
Yes, James argues the statute fails to regulate conduct. It operates purely on a subjective state of mind.
To back this up, he quotes another foundational case, right?
Yes, an 1879 Supreme Court decision called Reynolds v. United States.
What did Reynolds establish?
It established the fundamental First Amendment principle that legislative powers of the government reach actions only and not opinions.
And because the no-fault statute doesn't require proof of actions.
Remember, James emphasized that no evidence of abuse or abandonment was presented.
Right. So the state is directly regulating opinion.
That is his claim.
So how did the Oklahoma Court of Civil Appeals handle this First Amendment claim? They couldn't just brush it away with a territorial case from 1888 this time?
No, they rejected it. But they did so by utilizing a very specific and highly controversial legal framework.
Okay, what framework?
The Court of Appeals cited a famous Supreme Court case called Employment Division v. Smith.
Wait, Smith, that is the peyote case, right, from the 1990s?
Yes, the 1990 case involving two Native American men in Oregon. They were fired from their jobs as drug rehabilitation counselors because they ingested peyote as part of a religious ceremony.
At their Native American church.
Right. They were subsequently denied unemployment benefits because they were fired for misconduct. So they sued, claiming the state was violating their First Amendment right to the free exercise of religion.
And the Supreme Court, in an opinion authored by Justice Antonin Scalia, ruled against them.
Scalia held that the Free Exercise Clause of the First Amendment does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability, even if that law incidentally burdens their religious practice.
Okay, so the law banning peyote wasn't written to target Native Americans. It was a general criminal law.
Exactly. The burden on religion was just an incidental byproduct.
So the Oklahoma Court of Appeals looked at James Aikins' divorce statute, declared it a neutral law of general applicability.
And basically said, look, even if this divorce goes against James's personal or religious beliefs about marriage, the state has a right to enforce neutral administrative laws regarding civil status.
But James looks at that and says that is a total, fundamental mischaracterization of his argument.
Completely. James's petition is incredibly aggressive on this point. He states plainly that he is not claiming a religious burden.
Right. He isn't asking for a religious exemption to a criminal law.
He argues that Smith is completely inapplicable to his case because Smith involved a regulation of conduct, the physical, chemical ingestion of an illegal drug, peyote.
The state in Smith was regulating an action.
Right. But James says the Oklahoma divorce statute doesn't regulate conduct at all.
Because there is no behavioral standard being enforced. There is no misconduct required. There is no breach of duty.
It directly regulates belief itself, making the petitioner's subjective opinion the sole operative legal fact.
His brief puts it perfectly, actually. I have it here. When the government gives legal effect to one party's viewpoint while making the other party's viewpoint legally irrelevant, it is engaged in viewpoint discrimination.
He argues the Court of Appeals entirely ignored the viewpoint discrimination framework, which is a free speech issue, and instead forced his argument into a free exercise religious box just so they could easily dismiss it using the Smith precedent.
Man, and honestly, if this were the end of the story, James's petition would likely just be an incredibly interesting, highly theoretical, but ultimately long-shot pro se filing.
Most likely, yeah.
The Oklahoma courts dismissed his free speech argument by classifying divorce as an administrative process of general applicability. It seemed like a dead end. But just as James is drafting and filing his petition for writ of certiorari to the Oklahoma Supreme Court, the United States Supreme Court drops a massive landmark opinion.
An opinion that completely reframes the entire national debate over state power, professional conduct, and viewpoint discrimination.
And this is where the legal architecture of the two cases collides. We must turn our attention to the recent Supreme Court decision in Chiles v. Salazar.
This is where it all comes together.
So let's set the stage for Chiles. We're looking at a 2026 Supreme Court opinion originating in Colorado.
The factual background of Chiles is critical to understanding its impact on the divorce case. Ms. Chiles is a licensed professional counselor in the state of Colorado. She filed a constitutional challenge against the state's minority conversion therapy law.
What does that law do?
This Colorado law explicitly bans talk therapy aimed at changing a minor's sexual orientation or gender identity.
Okay, but there's a catch, right?
A big one. The exact same law explicitly allows talk therapy that accepts or supports identity exploration or transition.
So let me make sure I understand. If a minor comes to Mrs. Chiles experiencing distress about their gender, she is legally permitted to provide talk therapy that affirms the minor's transition.
Yes.
But she's legally forbidden, under threat of losing her professional license, from providing talk therapy that attempts to help the minor align their psychological identity with their biological sex.
Correct. Mrs. Chiles filed a pre-enforcement challenge. She argued that this law violates her First Amendment rights because it regulates her speech based entirely on her viewpoint.
What did the lower courts say? How did they justify the law?
The lower courts, specifically the 10th Circuit Court of Appeals, denied her request for an injunction. And listen very closely to their reasoning, because you will hear the exact same legal defense that Oklahoma used against James Aikins.
Oh, I'm listening.
The 10th Circuit held that Colorado's conversion therapy law is best understood as regulating professional conduct. Specifically, the medical treatments and therapeutic modalities provided by a licensed healthcare professional.
All right.
They reasoned that the law only regulates speech incidentally to that professional conduct.
Wait, hold on. So the 10th Circuit basically used the Smith defense.
Exactly.
They said, the state isn't targeting your speech. The state is regulating conduct, the practice of medicine, and if it happens to restrict your words during that therapy, That's just an incidental burden.
That is exactly what they said. And because they classified it as a regulation of conduct rather than a restriction on speech, they only applied rational basis review.
Wait, let's pause on strict scrutiny versus rational basis, because this is the hinge upon which this entire constitutional battle turns.
It is the whole ballgame.
From what I understand, rational basis means the government basically just needs a pulse and a somewhat logical, conceivable reason to pass a law, and the courts will rubber stamp it. It's the lowest bar in constitutional law.
Right. The government almost always wins under rational basis.
But strict scrutiny is a legal death sentence for a law. The government has to prove it has a compelling, urgent interest and that the law is the absolute least restrictive way to achieve it.
Very few laws survive strict scrutiny.
So by the 10th Circuit applying rational basis, they essentially gave Colorado a free pass to ban the therapy.
They did. But the Supreme Court, granted certiorari, took the case and reversed the 10th Circuit in a sweeping landmark decision authored by Justice Neil Gorsuch.
And in doing so, he completely annihilated the conduct defense.
He took a legal sledgehammer to that entire argument.
I read Gorsuch's opinion, and what struck me wasn't just that he protected the speech, but how he did it. He basically accused the state of playing a bureaucratic shell game, like trying to hide blatant viewpoint discrimination under the boring administrative label of professional conduct. He refused to let the First Amendment be defeated by a technicality.
Gorsuch cuts straight through the labeling. He writes that the First Amendment protects the inalienable right of every individual to decide for himself how best to speak.
Powerful.
He states unequivocally that Colorado's law regulates speech based on viewpoint. It permits one message, acceptance and support, and it outright bans the opposing message, attempts to change orientation or identity.
To understand Gorsuch's logic, it's like the state banning books about democracy, but defending it in court by saying, we aren't banning the idea of democracy, we are just regulating the conduct of using ink and paper.
That is a perfect analogy.
Gorsuch is saying you cannot regulate the ink and paper just to silence the idea.
I will quote directly from the syllabus of Gorsuch's opinion here. The First Amendment is no word game, and the exercise of constitutional rights cannot be circumscribed by mere labels. He meets that as a talk therapist, all Ms. Chiles does is speak with clients. She doesn't prescribe drugs, she doesn't perform surgeries, she doesn't engage in physical interventions. Her entire practice is dialogue.
So calling it conduct is just a label.
Right. He warns that if the government could simply reclassify talk therapy as conduct or a treatment modality to avoid strict scrutiny, it could wield laws regulating conduct to silence any speech it disfavors across all professions.
He writes this incredible line, if a government could reclassify talk therapy as speech incident to conduct, it might just as easily do the same for speech incident to teaching or protesting. What an opportunity for the suppression of dissent this would offer.
It is a terrifying thought.
That is a powerful, almost terrifying rebuke of the idea that the state can just wave the magic wand of the word conduct to bypass the Constitution.
Gorsuch reinforces that the First Amendment stands as an impenetrable shield against any effort to enforce orthodoxy in thought or speech.
Whenever a law suppresses speech based on viewpoint, it is an egregious assault on the Constitution, and it immediately triggers strict scrutiny.
And, stripped of the conduct armor, the Colorado law failed to survive that strict scrutiny.
But we have to note, this was not a unanimous decision.
No, it was deeply contested.
To fully understand the tension here, we have to examine Justice Ketanji Brown Jackson's dissent. She vehemently disagreed with Gorsuch, and she makes a highly compelling argument about the nature of state power.
What's fascinating here is that Justice Jackson's dissent is deeply rooted in the traditional police powers of the state.
Right. She argues that context is absolutely everything.
Mrs. Chiles is not a private citizen speaking on a soapbox in a public square. She is providing medical care to a minor as a licensed healthcare professional operating under a state-granted license.
She writes, under our precedents, bedrock First Amendment principles have far less salience when the speakers are medical professionals and their treatment-related speech is being restricted incidentally to the state's regulation of the provision of medical care.
Jackson argues that states have a long-established vital history of regulating the healthcare professions to protect their vulnerable residents from harm.
She points out that the state isn't targeting Ms. Chiles's speech as speech. They aren't trying to suppress her message ideologically out in the public sphere.
Exactly. They are trying to enforce a clinical standard of medical care that has been adopted by the broader medical consensus, which views conversion therapy as harmful.
She says the fulcrum of the constitutional test is the state's objective. Is the state aiming at professional speech, or is the restriction a mere byproduct of healthcare regulation?
For Jackson, the restriction on Ms. Chiles's words is purely incidental to the state ensuring that licensed professionals provide high-quality, safe care.
Jackson warns that the majority's opinion opens a highly dangerous door.
She asks, essentially, if verbal therapies are now fully protected speech, subject to strict scrutiny, how can a state enforce any standard of care in psychiatry or psychology?
Right. She argues that medical professionals do not have a constitutional right to use the First Amendment as a weapon to avoid reasonable conditions imposed by the state on their medical licenses.
It is an incredible tension.
Because on one hand, if the state licenses a professional, a doctor, a therapist, a lawyer, we want a state to dictate the standard of care.
Of course we do.
If a licensed doctor starts verbally telling patients that drinking industrial bleach cures cancer, we want the state to immediately revoke their license. We don't want that doctor claiming his advice is protected free speech.
Where does reasonable medical regulation end and viewpoint discrimination begin?
That is the exact tightrope the Supreme Court is walking in Chiles.
Gorsuch and the majority argue that while the state can easily regulate physical interventions, prescribe factual disclosures, and punish malpractice, it crosses the constitutional line when it dictates the viewpoint a professional must express during purely verbal, ideological counseling.
But Jackson argues that in psychiatry, the verbal counseling is the physical treatment, and therefore falls entirely under the state's broad power to regulate medicine.
Right.
Okay, so we have this massive, landscape-altering First Amendment ruling from the Supreme Court. It clarifies that states cannot use the guise of regulating a process or labeling something professional conduct to enforce a specific viewpoint and silence an opposing one.
Which brings us to the convergence.
Yes. How does a case about conversion therapy in Colorado arm a pro se litigant fighting a divorce in Oklahoma?
Let's connect the procedural dots here. In the Aikins divorce case, James argued the no-fault statute was viewpoint discrimination because it elevated his wife's subjective belief of incompatibility to an absolute legal fact,
while completely silencing his opposing belief that they were compatible.
Right, and the Oklahoma Court of Appeals rejected that by saying the statute was a neutral law of general applicability, essentially saying we are regulating the administrative process of divorce, which is conduct, and any impact on your beliefs is just incidental.
They used Employment Division v. Smith.
Yes, they did. But look at what just happened in Chiles v. Salazar. The state of Colorado used that exact same defense.
Right. Colorado said, we are regulating the medical treatments provided by therapists, which is conduct, and any impact on Ms. Childs' speech is just incidental.
And the Supreme Court, via Justice Gorsuch, completely obliterated that defense when it involves viewpoint discrimination.
I see the mechanism now. James Aikins can look at the Supreme Court's ruling in Chiles and say, the Oklahoma Court of Appeals' reliance on Smith and the incidental burden on conduct offense is fundamentally dead post-Chiles.
Precisely. In Chiles, the Supreme Court explicitly ruled that the state cannot favor one side of an ideological issue and silence the other under the guise of regulating a process.
And James argues Oklahoma is doing exactly that.
He asserts that determining whether a marriage is incompatible is fundamentally an ideological, subjective question. The state is elevating the wife's subjective viewpoint to a state-sponsored mandate to dissolve a civil status,
while legally gagging the husband from offering any objective defense.
Right.
And because we established earlier that the wife presented absolutely no evidence of abuse, no evidence of misconduct, and no proof of a breach of duty.
James can argue the divorce statute isn't regulating conduct at all.
It's pure regulation of belief, just like the talk therapy in Chiles.
Furthermore, remember Gorsuch's warning. He warned that allowing states to reclassify speech as conduct to avoid scrutiny would create a massive loophole for suppressing dissent.
Oh, man.
James can argue that the Oklahoma legislature reclassified the purely subjective belief of incompatibility as a legal cause of action, specifically to bypass the traditional requirement of proving a breach of contract.
They labeled belief as conduct so the state could unilaterally dissolve marriages without facing strict constitutional scrutiny.
Exactly.
Wait, so this guy without a law degree has managed to weave together a 200-year-old caveat from John Marshall and a brand new Supreme Court ruling on conversion therapy to create a constitutional trap for the family court system.
It is truly remarkable.
This completely transforms the Aikins petition. What might have been viewed by the appellate judges as a novel, perhaps eccentric, pro se argument by a frustrated husband is suddenly armored with the latest First Amendment precedent from the United States Supreme Court.
The Chiles decision provides James with direct Supreme Court authority. It states that governments cannot dismiss First Amendment scrutiny by labeling a process administrative when the operative mechanism relies entirely on subjective belief and expression.
It is a remarkable synthesis of legal concepts. James is using the sword forged by a First Amendment challenge to conversion therapy bans to attack the statutory bedrock of no-fault divorce.
He is forcing the courts to reconcile two radically different spheres of law.
So what does this all mean for the listener? We've gone from a family court in Oklahoma to the chambers of Chief Justice John Marshall in 1819 and back to the modern Supreme Court. Why should someone listening to this deep dive care about this highly technical intersection of the contract clause, Chiles v. Salazar, and an Oklahoma divorce petition?
Well, because it forces us to ask fundamental questions about the nature of the agreements we make and the true extent of the government's power over our personal lives.
Right.
We have seen how the definition of a contract, the historical legacy of the Dartmouth decision, and the modern evolving boundaries of the First Amendment all collide in family court.
The state's power is incredibly vast, especially when it comes to domestic relations and public welfare.
But the Constitution demands rigorous, uncompromising scrutiny when that power touches upon individual belief, expression, and the fundamental obligations of contracts.
Marriage is the most common civil contract that everyday citizens enter into. It carries massive, life-altering implications for property, for civil status, and most importantly, as James Aikins argues, for the parent-child relationship.
Understanding what legal rights you actually possess within that contract is vital.
Does the state have the absolute power to unilaterally alter your civil status, divide your assets, and alter your access to your children based on nothing more than someone else's unproven subjective belief?
Or does the Constitution draw a hard line in the sand?
If James Aikins is right, the state has been crossing that constitutional line for 50 years by ignoring the Dartmouth exception and engaging in systemic viewpoint discrimination.
And the Chiles opinion gives his argument a level of contemporary relevance that the Oklahoma Supreme Court, and perhaps eventually the United States Supreme Court, will find very difficult to brush aside.
Which leaves us with a final, lingering scenario to explore. We started this deep dive by imagining a contract that the other party could dissolve at any time just by stating they believed it was broken.
Right.
We've explored how a pro se litigant is using the contract clause in a brand new First Amendment ruling to challenge that reality. But let's look over the horizon. Let's imagine James Aikins wins.
Okay, let's play that out.
If the Supreme Court ultimately agrees with arguments like those presented in his petition, if they rule that unilateral no-fault divorce, without proof of an objective breach, violates the contract clause and the First Amendment, how would society actually adapt?
The ramifications would be immediate and seismic. You would be unwinding 50 years of family law infrastructure overnight.
Think about property division. Currently, in many states, assets are divided equitably regardless of fault.
Right. But if we return to a fault-based system, a breach of the contract, like adultery or abandonment, could entirely dictate who gets the house, who gets the retirement accounts, and who pays alimony.
The financial stakes of proving a breach would skyrocket.
They absolutely would.
But what about child custody? If a parent has to prove the other parent breached the marital contract to get a divorce, does that breach automatically render them an unfit parent?
We could see courts overwhelmed with microscopic examinations of marital conduct. It could plunge families into years of bitter, expensive litigation just to sever the legal tie.
Or perhaps it would force a total reimagining of what a marriage contract legally requires from day one.
If the state can no longer provide an easy, no-fault exit, couples might be forced to negotiate their own exit terms before the wedding.
We could see a rise in highly customized, heavily negotiated marital contracts that look more like complex corporate merger agreements than romantic vows.
Couples would have to define, in writing, what constitutes a breach of duty in their specific relationship.
It fundamentally changes the cultural definition of marriage from a state of emotional being to an enforceable list of mutual obligations.
It's a profound thought.
Are we prepared to treat marriage with the absolute legal severity of a corporate charter? Something to think about the next time you put your signature on the dotted line.